Hello, everyone. Welcome to this webinar on simple legal solutions for common business headaches. I am your moderator, Jenny Alton from the New York Small Business Development Center Central Office. This webinar is brought to you by the NYSBDC. We are a U.S. Small Business Administration resource partner with regional centers at higher education institutions and outreach offices at other locations across New York State. Our free advising, education, research, and advocacy services are made possible by funding from the SBA, New York State, and our host campuses. We are so pleased to have with us today Alex Hurd, owner of Hurd Law Office. So you know, we are recording, and we will share links to a PDF copy of the slides and the recording in a follow-up email. Attendees are muted and will not appear on camera today. Your chats will only be visible to me and our presenter. If you have any questions during the presentation, please don't hesitate to type them in the Q&A box as they come up. You can open Zoom's Q&A box from the Q&A button at the bottom of your Zoom window. We will address questions during some pauses throughout the presentation and catch any others, I guess, at the end, time permitting. But we'll try and get questions answered as we proceed through the presentation today. And with that, I will now turn the time over to Alex.
Thanks so much, Jenny. Hello, everybody. Thanks for joining. As Jenny mentioned, this is Simple Legal Solutions for Common Business Headaches. I'm Alex Hurd from the Hurd Law Office. First, just wanted to thank Jenny and the New York Small Business Development Center for hosting this. Today, what my goal is to go through some of the more common questions that I hear from my clients who are business owners and their pain points, and discuss some of the simple ways that I recommend helping people through legal solutions. So be kind of a high-level overview, hopefully give you some practical information that you might be able to use, whether it's knowing what questions to ask or steps you might want to take to help protect your business. We do have both the chat and the Q&A open. Feel free, if you'd like, to add any information into the chat, whether it's the type of business you have, challenges or frustrations you've been experiencing, or even any experience you've had, good or bad, working with lawyers. I want to be conscious of everybody's time. I'm not going to go over, but I will try to incorporate some of your questions and information into the presentation today. So feel free to submit that in the chat at some point. A little bit about me. I really love helping small business owners. I started my own law firm about 6 months ago. Prior to that, I had been working in business law and with nonprofits for about 10 years. But now, as officially this year, I am also a small business owner myself, so I have firsthand experience dealing with a lot of the problems and issues that small business owners have. I work very hard to find practical and affordable solutions for business owners to attach these issues. I understand that legal fees are not cheap, and while I wouldn't describe myself as cheap either, I work hard to find efficient solutions to help people deal with those issues that they're dealing with. And I do a lot of speaking engagements such as this. I've also taught continuing legal education classes for other lawyers about topics on business law and outside counsel services. Again, my goal is to really help educate the community about what steps that they can take to protect themselves. So today, what I'm going to get into, it's 4 topics. The first is strategies for dealing with non-paying clients. These are steps that you can take both proactively and reactively to try to help deal with the situation if you have a client that's not paying you. The second is vendor agreement issues, and this is sort of the reverse of the first. Now, this is where you're the paying client and you have a vendor who is, for whatever reason, not living up to the agreement that you had with them. And we'll talk through some strategies that you can take to try to improve that situation as well. Third, I'm going to talk about preparing for growth, and this is really in 2 parts. So the first is for businesses that are thinking about or have already hired employees, and some considerations that you may have with that. And we'll also be talking about businesses who may want to add business partners and what considerations you should have when you're adding a business partner to your business. And finally, we'll talk about navigating partnership disputes. So this is the unfortunate side of things when those business relationships, internal business relationships go wrong, what you can do to kind of prevent that from happening in the first place, and steps you can take after the fact. One caveat I have to give at the beginning of this presentation, there is a joke within the legal community that is the answer to every single question can be answered with "it depends." And the reason for that is there are a lot of nuances and a lot of exceptions built into the law. So I'm going to give some high level information for you that hopefully is helpful, but please consider it only general advice. The only way that to know that if anything I'm talking about applies to your particular situation or your particular business would be to have a consultation with a lawyer. So I just want to throw that out there. And I can almost guarantee if I get a question today, I will have to answer with "it depends." It happens every time. All right, so the first topic we're going to talk about is strategies for dealing with non-paying clients. One of the things I'm going to be saying a lot throughout this presentation is the importance of contracts. A lot of business owners who I speak to often start out without even thinking about having a contract for them to have with their own clients. Sometimes it's worrying about that it might scare their clients off. Sometimes they just started out by drawing up a proposal and having a handshake agreement or signed proposal and going from there. And a lot of times that works out just fine for most of the time, but it's almost inevitable that eventually you have a dispute with a client and you're going to wish that you had a contract in place. So the number one recommendation for a proactive approach at dealing with these sorts of issues is to have a contract and to understand what type of terms you want to have in the contract. So one of the important things you can put in there is a schedule. Now, depending upon the industry your business in, this may or may not apply, but a lot of times clients expect things on a certain timeline. And having that timeline laid out in the contract from the beginning can really save a lot of headaches. It makes sure you and your client are on the same page, and also can dictate what happens if that schedule needs to be changed for some reason. Maybe it's something out of your control, maybe it's a delay on your part, but having a detailed agreement ahead of time prevents that dispute that can happen, and that I'm sure a lot of people have been on both sides of, where something's not getting done in the time that you expected it to. Another thing that can come up is late fees. So I want to talk a little bit about one of the strategies I really recommend overall, which is making sure that you get some type of payment up front, and then also have a plan in place for late fees if your client is not making those payments on time. Now, there's two real benefits to getting payment up front. So the first of which is simply from a practical matter, if you collect half of your payment up front and the client then later down the line refuses to pay for some reason, you're now out only half of the project cost instead of the full project cost. You could even break that into multiple different tiers. So for instance, you could have 25% up front, you could have 25% when stage one of the work is complete, another 25 at stage two, and then the final 25 at the end. And if you run into a problem at stage two, for instance, again, you've collected 50% of the payment and you haven't even finished the other 50% of the work. Maybe you've done only 25% that you're not getting paid for. So this is a great way to kind of hedge your bets a little bit. And if you do this enough with clients over time, you're going to find out that even if you have clients that stop paying you and you're unable to recover that amount from them, you've saved quite a bit of money just by doing that. The second thing, which is also a practical consideration, is it'll give you a good insight into which clients may be problems and may not be the clients you want to take on in the first place. If you're asking for 50% payment up front and they're struggling to make that or trying to fight you on the price, delaying, whatever it may be, that might be some insight into the fact that they're going to be more trouble with their worth. And it may make you reconsider the deal or maybe just create even stronger payment terms for yourself. Now, again, this is something that should be built into the contract and spelled out clearly. So using my example where you take 25% tiers, hypothetically say you're in a construction industry where you're saying that once the project is a third of the way done, you'll get paid 25%. Well, what does a third of the way through building a house mean? There's got to be something that's laid out in the contract that really specifies exactly what needs to be done for you to reach that first tier and get that first payment. And if not, that's an area where you can create a dispute. And again, contracts really at their core are about trying to anticipate potential disputes and avoid them at the start, or at least describe what will happen if that dispute comes up. Now, how late fees play us into this is, I'm sure I alone am guilty of this. I'm sure a lot of people are too. Suppose you get a bill from a doctor's office or someone that you owe money to, and you're a little bit struggling for money at the time, or you're thinking about a paycheck that's coming down the line, and you may think to yourself, you know what, I'll wait a month, I'll pay it next month. 1 month could become 2 or 3, and suddenly you're just sitting there waiting while your doctor's office or whatever business you hired is waiting to get paid. Well, now you're the business in this case, and so you may have a client that has every intention of paying you eventually, but they're fine waiting for that. Well, so what a late fee does is it gives you the ability, you can pick a timeline, put this into a contract and say after 30 days, 60 days, whatever the time is, you're now going to charge them a late fee if they don't pay on time. Now, if you put yourself back into the shoes of the person who's waiting and just figuring you'll pay it eventually, well, now if suddenly you're going to get a 5% charge added to your bill or whatever the amount is, you might be a lot more motivated to pay on time. So this accomplishes that. First of all, it gets people who are just either being lazy or have no problem waiting. It motivates them to pay on time. But the second thing it does also is if you do need to go and you need to go through a legal step, which we'll talk about in a moment, to recover some of the payment, you're now adding on to that amount, which will hopefully offset some of the time and the energy that you're going to spend on chasing them down for the payment as well. So it really works on both fronts. Um, the last contract term I'll talk about here is dispute resolution. So I will get into some of the different options here. I think a misconception that a lot of business owners have is that if you need to go after a client for payment, your only option is to file a lawsuit. Filing a lawsuit is definitely an option, but it tends to be a very time-consuming. It takes sometimes years, depending upon the complexity, to go from start to finish on a lawsuit, and it can also be quite expensive. So a lot of times, especially smaller businesses, it's advised that you consider something like arbitration or mediation as an interim step because you can often get the result you're looking for through one of those stages without having the long time period and the significant amount of money that can be invested in that. So it's an important thing to, again, agree ahead of time because it's much harder to do after the fact. Now, tied into all this, I recommend that clients often create an escalation process. And what this means is creating sort of an internal guidance that you have for yourself and for your company, where you have timelines where you start to increase the escalation for how much, or excuse me, for the methods that you're using to ask for the payment, or in some cases, the threats you need to make if it's been a significantly long time. And this ties into the contract. So if you know that you have a contract you always use with clients, and it says that basically they have 30 days to pay. If they don't pay within 30 days, you have a chance to charge a late fee. If they don't pay within 60 days, you have the option to stop work. You're going to build that into your escalation process. And for every client that you have, you'll keep some sort of schedule. And when you hit these milestones, so using that example, say after 2 weeks, you send a polite email reminder. Say, reminder, payment was due within 30 days. It's now been 15 days. Please make the payment. You get to 30 days, you might send out a slightly more terse email that informs them that you're going to charge the late fee if payment isn't made within another 10 days. See what happens. If you hit the 10 days, now you're charging the late fee. You're reminding them you're going to stop work if they're not paid. Whatever it is, whatever works for your industry, whatever makes sense with your contract, having that system built into place and keeping a schedule that you use for every client is just a good practical step that can help make sure that you're not letting any payment amount slip by. Now, of course, even with taking these proactive steps, it doesn't guarantee that your client is going to make the payment, doesn't guarantee that you're not going to run into issues. So at some point, you may come to a stage where you need a lawyer to assist. Now, one of the interim steps that can be taken before you're filing a litigation or arbitration or whatever it may be is called a demand letter. And what that is simply a law firm sends out a letter that's going to be on a lawyer letterhead that informs your client that they owe you money and that they have to make a payment by a certain date, or you're going to consider other legal options. A lot of clients, that's all it really takes to get motivated by it. It's kind of similar to a late fee idea, but just a step up from that, where they may be thinking you're going to forget about it, you're going to let the payment go, but now they have a real stern reminder that you're not going to let it go, that you're going to need that payment, or you may end up in court. And oftentimes that can get people to come to the table just from that. Um, Another option before you get to filing anything would be negotiation. Now, depending upon the balance that a client has, this may or may not be worth it. But if it's a particularly large balance, having a lawyer step in and try to negotiate some sort of payment plan, or if the client is not paying because they claim that some of the work wasn't performed correctly or on time or whatever it may be, they may be able to negotiate sort of a middle ground that works for everybody. Again, it's going to be very situational, but that is an option that a lawyer can help with before you get to any sort of lawsuit. And then, as I mentioned, you have mediation or arbitration options. For anyone who doesn't know what arbitration is, it's basically a much smaller version of court. There's no jury, there's no judge. There is an arbitrator who will still hear witness testimony, but it tends to be quicker and more cost effective than going to court. And then there's also small claims court. If the amount is small enough, small claims court is considerably cheaper and quicker than going to a bigger court. It's not as good for more complex issues, but if it's simply a matter of client hasn't paid, maybe they say that the work wasn't done right, that's something that a small claims court might be able to handle in a much more cost-effective manner for you. And then lastly, collection agencies. There are agencies, there are also law firms that handle just collections. And this is usually where you have one of two options. One is you'll basically pay them some amount of money to take on the case, and they'll usually get some sort of, or instead of paying them upfront, they'll get some sort of percentage of the recovery, or it could be that they'll just take the debt off your hands entirely and pay you some amount of it after the fact. But either way, you can have these agencies or these law firms kind of step in and collect for you. A lot of times you're giving up a good percentage of the recovery if you do that, but it means it's less you don't have to worry about. You're not involved with a lawsuit either. So those are some options to consider for people both on the proactive and reactive step. And I'll talk about quickly some real life examples of how this can work in practical terms. So the first one is a consulting company that was experiencing significant delays in payments from their clients. I worked with them to revise their contracts, which included clear payment terms, deadlines, and penalties for late payments. By establishing this more structured agreement, they saw a substantial reduction in payment delays, and they're able to use those penalties as a motivator for clients with late payments. Second real life example is an accountant firm that had difficulty securing payments after delivering their services. I recommended help them implement retainer agreements, which is what I talked about, where a portion of the payment is paid upfront before their work even started. This not only guarantees, as I mentioned, you get partial payment, but also demonstrate the client's ability and willingness to pay before the work was complete. To help them out there as well. So the flip side of that is vendor agreement issues. And again, this would be where your company is hiring someone else to perform work for you. And you can definitely run into similar issues here, although things will be reversed. So some of the common things that come across with vendors is simply breach of contract. And that can include things such as quality discrepancies. So if you're hiring someone to create a website for your company and the website doesn't function correctly, it doesn't look good, whatever it may be, certainly may not be happy with the quality. Late deliveries, not all times when you hire a vendor is the timing going to make a huge difference, but especially if you're in some sort of retail situation or if you have a real estate closing, whatever it may be, having a late delivery that pushes back deadlines can certainly be harmful, and it's something you definitely want to document in contracts ahead of time. Again, I'm hitting the contract drum, but it is important. Change orders. This is most common in the construction industry, but it can come up in other industries as well. So change orders is essentially where you start the agreement with a scope of work in mind, and as the project goes on, for one reason or another, the parties decide to change the scope of work. So in construction, that may mean, for instance, you've decided you want to do renovation on a second room when you only thought of the first, or maybe you want to change to use a more expensive material than you originally decided, whatever it may be. And the terms for that should be laid out because the parties are going to have to agree. If you're changing the scope of work, what does that mean for the timing? What does that mean for the cost? Increase or decrease of cost is another one. And I'll use an example here. If people remember, right after COVID happened, the construction industry was hit very hard with price increases. The cost of lumber, the cost of materials, everything just shot up. And some of the things increased 200, 300, 400%. And so one of the issues that came up here is that construction companies who had long-term projects, who, multi-year projects, had agreed upon a price based on the price of lumber and the price of these materials at the time of the contract. Well, a year goes by, 2 years go by, and suddenly these prices go up so much that they're now would be forced to operate at a loss. They would basically be taking a loss to complete the contracts that they had in place. So what do you do? Unfortunately, I mean, that's a hopefully once in a lifetime situation. So that's a particularly extreme example. But if you have some idea in place of what happens if the price of goods involved increases or decreases, again, that can be built into a contract ahead of time. So you're not scrambling to figure it out down the line. So when you have an agreement with a vendor, there's a few things that should really go into that. The first is the scope of work. As I mentioned in the other scenario, it's important for both you and for the vendor to understand exactly what your idea is. What are they going to be providing for you? Is it, if you're saying a website, do you want building a website, you may want to say how many pages does that website include? Does it have sub pages? Will there be a contact box built into it? You detailing these things in with a lot of specifics as opposed to just saying build a website can make a big difference. Payment terms. So this again is, are you paying upfront? Are you paying in intervals throughout the course of the project? Is everything due at the end? And then if it matters, payment methods. Can you take a cash payment? Does it have to be by credit card, etc.? Those are things should be worked out ahead of time. Delivery timelines. So one example to give here, suppose you own a deli and you sell diet soda. You're used to getting diet soda shipments at the first day of every month. And it's important that you have that because you tend to run out of diet soda to sell around that time. So if the delivery is late by a week, suddenly your shelves are empty from diet soda. You may have customers that come in there. So not only are you losing sales, but what if those customers decide, oh, they don't even sell the soda I like, I'm going to go to a different deli from now on? You could lose customers long term. So if a delivery schedule is really important, that should be specified for reasons like that. Minimum standards. So this has to do with the quality issues. If you are buying a product, for instance, from a vendor, and it needs to meet certain qualifications, it needs to function correctly, then that should be built into the contract. Again, the more detail you can put into it, the better. And then penalties is an interesting one. So there are a lot of different considerations that go into this. One example, again, using the delivery timeline, suppose we're talking about the deli example, diet soda is not there. It could be one thing to just say, well, they didn't deliver it, I'm going to cancel this month's delivery, not get a refund for the month and move on. But that doesn't answer the question of what do you do to make sure you don't lose customers. And what you may be doing is running down to a third party that sells Diet Coke, buying it from them so you can keep your shelves full. And it may make sense in an instance like that to include penalties in the agreement that basically say, hey, if you deliver this product late, I'm going to go to a third party to buy it because I need it on my shelves, and you're going to pay me the difference from what I would have paid you for this product because I'm not losing out as a result of your late delivery. That's something to consider in there as well. And then there could also be other areas we get into. So if you are a manufacturing company and you have an agreement with a distributor to sell your product in exclusively in a geographic area, and your distributor is not performing as well as you would like, you could build in, say, a 6-month review period where you meet with them and say, you know what, this is not cutting it, and we're either going to need to cut out your exclusivity, or maybe you have the right to terminate that contract altogether. Again, there's a lot of different examples I could give, but this is across many different industries. But hopefully, these are a few examples to keep in mind of different things that, again, if you're able to build this into the contract from the start, as opposed to trying to figure out what resolves it after the fact, it gets everybody on the same page from the start. And then dispute resolution, that's similar to what I talked about with the last slide. Knowing your options for resolving an issue if it comes up is really important. So preventative strategies, again, contracts, hopefully that's a clear point that comes across. Building all this in the beginning is going to save a lot of time and stress down the line. Regular performance reviews are something that, depending upon the nature of the relationship, could make a lot of sense. So going back to my manufacturer distributor example, if you have built into the contract that you have every 6 months, you can sit down and review the performance they're doing. That gives you an option to potentially, as long as the contract is drafted correctly, modify the contract or even terminate the contract. Because a lot of times you have these long built contracts or these long relationships between parties, And if you have no way to get out of it, you may be stuck into an underperforming arrangement for a long period of time. So having a performance review, and most importantly, having a performance review where you have the ability to make changes based on the review, can be really helpful based depending on the industry. Clear communication is good life advice, but it's also good advice in business. If you have an issue with the vendor where they're not performing up to the standards that you want them to, they may not be aware of that unless you clearly communicate with the issue and give them a chance to rectify it. So a lot of times contracts will have what's called a cure period, which is essentially if you raise a concern over the quality of the work that's performed by the vendor, they'll be given some number of days, weeks, whatever it may be, to correct that. And that allows them to remedy it. The other potential thing to keep in mind here is if you have, let's say, a year-long contract with somebody and you go 3 or 4 months where you're getting deficient products or the vendor's not performing up to the standards you'd like, and you don't say anything for those 3 or 4 months, it's possible that they might be able to argue that you waive the right to do so. And you may be prohibited from raising those concerns in the future. So again, good life advice, good business advice. Make sure you communicate any issues during the life of the agreement. Project manager or owner's representative. So this is again common in the construction industry, but you can hire somebody who essentially is given some power to oversee the project by you. And in some cases, you can even structure it where they ultimately have to sign off on if the vendor has the right to get payment, or if they're able to raise objections or concerns on your behalf and require the vendor to address those before a payment is due. So it can be really helpful just to give a third party that they work for you, but they're a third party who can oversee the process and provide input. And then contingency planning, what happens if we don't get what we need from the vendor? So using the deli diet soda example, if you take those steps ahead of time to figure out, all right, if we don't get this delivery, this is where we're going to go. This is the third party we're going to buy from and how much it would cost us to do so. You could even build that into the contract so you don't have to guess later on and say, as an example, if you don't make the delivery on time, you're going to refund us the money and pay us an additional $500 because that's what it's going to cost us to buy from a third party. So there's a lot of different ways you can build in contingency planning into the agreements, but even if it's not built into the agreement, knowing what your backup is again just good practical advice. So finally, legal remedies. I talked about most of these already. You could be asking for a future discount. You might have language that's built in to terminate the agreement altogether if they're not performing and it's a long-term contract. Never a bad idea to include an out clause for yourself. Specific performance is a legal term that essentially means asking a court to require the vendor to perform their obligations under the contract. These are rarely used in practice, but in some bigger transactions, you may be able to require the vendor to complete their end of the deal. Right to use another vendor, like I mentioned with the soda example, and then again, arbitration or litigation. I see a question came in, so let me answer this. Question is, my contract term was payment upon completion, and that date is come and gone. I sent a couple of follow-up emails to the client's finance email address on the contract and received no response. Reach out to my contact who introduced the client to me, and she informed me that the finance shared with her that their company practice is net 60 days. My question is, what are the steps to take when the client is not honoring the payment terms stated in the contract? So that's a great question. So first of all, as a starting point, the fact that you have a contract that requires them to make a payment before 60 days overrides their company policy. You have a written agreement. That's really what should be honored here. But the question then becomes, and this is something that comes up a lot in these sort of legal questions, is you have the law on your side, but what do you do practically with that? So the answer is if they're going to pay you in 60 days and you feel confident they're going to honor that portion of the deal, whether or not it's worth to kind of take any intermediary steps is a fair question. Is that going to harm the relationship between the client? So I'm going to use what I promised and say it does depend on the situation. It depends on sort of what your relationship is with that client and how to move, how you want to move forward. Is this going to be an ongoing relationship? If this is a one-time issue, Practically speaking, going 60 days and waiting for them to pay you at that point might honestly be the best practical option that's available. But if this is going to be a thing where you're going to be working for them month over month, and you're expecting this issue to come up again, you definitely want to nip it in the bud. So one thing you could do is in that instance is refuse to perform additional work unless they make the payment on time. You could also build in something with future agreements to do with late fees. You could also make potential threats to have a lawyer get involved if you need to. It would depend on looking at the situation, but I think it depends on the I'm saying it depends multiple times, but it does depend on what you ultimately want, both short and long term. But you have some options there. Usually refusing to honor your side of the agreement until they do is one of the more effective strategies. So hopefully that helps in between my it depends responses. So that move on to third topic, which is preparing for growth when you're hiring your first employees. So while I've set this up for first employees, this really can also apply if you've had employees for a long time and maybe never considered some of these issues. So the first thing I want to talk about is employment contracts. So New York is an at-will state, as most states are, which means that employees can be employees can be fired for any non-discriminatory reason, and employees can also quit for whatever reason they want. And so what that means is you don't necessarily need an employment contract. It's not uncommon for people to provide offer letters, or even just kind of discuss face to face what the job description is and how much is going to be paid. There are some requirements with making sure you properly document payment terms, but in terms of the actual employment agreement itself, you don't necessarily need it. But where the times I do recommend it to people are if you have your employees who are going to be working with confidential information, or if they are going to be dealing with technology a lot of the time, or creating artistic work product for you, things like coding, things like graphic design, logos, things like that. There are terms that you can put in an employment contract where essentially the employee is agreeing that anything that they create for you on the job is owned by the company. It's not owned by them. This can prevent them from going and running off and either starting their own company or giving it to another employer and having a dispute over who owns it. So not a bad practice to have them sign to agree to keep confidential information safe. It adds a level of protection for you. And then there were things, non-competes currently are allowed. They briefly were struck down at the federal level. The courts have overruled that. That's being challenged. So we'll see where that shapes out. Either way, New York was heading in the direction of banning non-competes on their own regardless. So while we can put non-competes in agreements, I am typically avoiding those for the most part and finding other strategies, such as non-solicitation agreements. That's where you tell employees that they can't try to bring your other employees on with them if they leave the job, where they can't also go to your customers after they leave the job and try to bring them to a new company. So there are other strategies to do that. If any of those provisions are things that are helpful to your company, then that's when you would want to consider an employment contract. Another thing to be aware of is labor laws. There's a whole body of labor laws, and I can't possibly cover them all in this setting, but two things I really want to mention are the two most common ways that employers get into trouble. The first is by considering a employee a independent contractor. And there's not a very clear test. A common misconception I think people have is that if you have somebody who is part-time versus full-time, the part-time person can be an independent contractor. That's not always the case. It really has to do with the job duties they're performing, with the level of control that employers have over the employees. There's a number of factors that get into it. It's not black and white. So if you are considering hiring somebody as an independent contractor, it is worth having a lawyer look at it to make sure that you're not misclassifying them, because that can result in some pretty large fines from the Department of Labor. And a lot of times what happens is independent contractor gets fired or leaves or something, and they go to file for unemployment. The unemployment board looks into it. So this person isn't listed as an employee, they're an independent contractor, but it sure sounds like they're an employee. investigation happens, fines can happen from that. So want to avoid that. And the second most common thing is some employees are exempt from overtime requirements. And oftentimes, again, there's a misconception that if you have an employee who is on salary, they don't have to be paid overtime, and if they are paid hourly, then they do. And again, it's not based on salary or hourly. It is based on their job functions. So if you are planning to not pay someone overtime, it's very important to make sure that they wouldn't qualify as non-exempt, because that can also add up in pretty significant penalties if they have to go look back at all the time an employee's worked for you, which they can go back years, and find out that you were underpaying them. That's not a great situation. So those are the two most common things to think about, but there obviously are a ton of labor laws in New York. An employee handbook I want to mention quickly. Employee handbooks are helpful. They are something that I think a lot of people will find from either an HR department or downloading from online. What an employee handbook does is it essentially allows you to create a system of or a number of policies for your business that in theory help protect you from discrimination claims, or any other claims from the employee. But the way this works would be is if you have an employee who asks to take time off for something and you say no, but it's in accordance with your internal policies, then that's pretty good evidence that you're not discriminating against them. You're following your business's policies. However, the part where people get into trouble here is if you just download a template employee handbook, and you save it somewhere, and you never actually bothered to make sure that the policies in the handbook match the policies of your business, then it's actually going to do more harm than good. Because again, using the PTO example, someone asks for time off, you say no, and that even if that's been your business practice the entire time, now you have a written policy that says something different, and under that policy, you should have given them that time off. Now they're going to go and claim discrimination and say, look, the policy says I should have gotten time off. I didn't. They're discriminating against me, and that's going to hurt you. So if you have an employee handbook, make sure that it matches the way you operate, and make sure you are aware of all the policies in there. It's a good thing to have, but if it's not going to match what you're doing, I would rather you don't have one. Training programs. This is a more of a practical thing for a lot of times, but this can be very helpful on the legal side of things for protecting your business. If you have employees that work in dangerous areas, or you have employees who work with kids, or maybe people with special needs, whatever it may be, the more risk there is that someone could potentially get hurt, or abused or something like that, then the more important it is to show that you are putting your employees through proper training programs. This will help give you a level of protection for if, God forbid, something does happen. You're able to say, look, we did what we could. We took the necessary steps to train the employee on this. It's either something they did wrong or accidents happen or something. It's not a foolproof method, but it definitely can help with that. Performance evaluations are good. Again, this is a good practical thing to do with your employees regardless, but one of the ways this is helpful is if you do need to eventually suspend or fire an employee. If you have performance reviews where you can document that you had multiple instances where you sat down with them and raised concerns about their performance, or other issues they may have on the job, then if they try to claim some sort of discrimination after you fire them, you can point to concrete examples of times you raised these concerns with them and their failure to take that into account. Now, it does a little bit work the opposite way, where I have seen times where businesses do performance reviews. They give very positive reviews to an employee. Then something happens down the line where they need to fire that employee, or they choose to fire that employee for some reason. And it certainly doesn't look great if you're going to claim it's for performance reasons if you have done all of these positive performance evaluations. Again, you can fire an employee for any non-discriminatory reason, so you don't have to claim performance reasons, but knowing when to use performance evaluations, and more importantly, knowing what the result of those were, can be important for navigating a potential termination situation. And lastly, a touch on severance agreements. This is essentially where you are giving an employee severance after they leave the company, usually when you are terminating them. A misconception sometimes employers have is that offering severance is just a nice way to help the employee get on their feet and give them some payment. That is true, but it also is important because a good severance agreement will have the employee, in exchange for that money, waive their right to sue you for discrimination or a host of other things. So yes, it is nice, and yes, you can certainly do that to help the employee, but you should also protect yourself and make sure that you're getting an agreement from them on the way out. And having a template severance agreements drafted ahead of time can be helpful because in the heat of the moment, if there's issues with the employee on the way out the door, you don't want to necessarily have to figure out the terms at that time. So another question that came in. So this question says, for training program requirements for new employees, is it a good idea to have a lawyer look over the training program requirements and job duties to help identify any legal discrepancies between the training and the actual job duties? So the answer is it's always a good idea to have a lawyer look over things like that to consider the legal options. I will say that this is one area that I don't necessarily know if you need to spend legal fees on. It may depend on the size of the company and the potential risks of the job that the employees are doing. In some cases, having someone from like an HR department may be sufficient if you're particularly worried about the job duties. Um, but if it is something that's particularly dangerous, like there are going to be specific legal requirements for things like working with kids, knowing who's a mandatory reporter in the event of abuse, things like security guards, weapons training, things like that. Like those are areas you probably want to have a lawyer look at it. But if you're just looking to train on sort of a more average job position, again, it's never a bad idea to have a lawyer look on it. It's just a matter of whether it's worth the cost of doing so. So again, it's sort of an independent answer, but hopefully that's helpful. Move along. Just very quickly to summarize what we've gone through so far. Hopefully it comes across the contracts are very helpful, whether it's for clients, employees, or vendors. Being proactive will pretty much always save time and money versus being reactive, which is why the conversations I have with my new business clients is often about creating contract templates for these sorts of things. Because again, one-time cost, you can use these templates over and over again to help offer protection for yourself. So next topic I'm going to get into, I'll move through this fairly quickly. This is about adding new business partners. So this is, again, I'm going to use the term business partner. It doesn't have to be a partnership. This might be adding owners in a corporation or an LLC, which would be considered members or shareholders. I'm using business partners loosely, though, to any sort of ownership in a company. Due diligence is, again, this is kind of a practical advice, but know who you're getting into bed with. Make sure that the person it isn't significantly in debt. They haven't been sued for managing other companies. If you're going to share ownership with somebody, it can be very tough to untangle those things. So just know who the person is. Financial contribution. So I think one of the most common examples people often think about when thinking of how to like buy into a business is probably from Shark Tank or something similar, where somebody says, I'll give you $100,000 for 30% of your company, which values the company at, she chose an easier math example, 350,000, something like that. And that couldn't be very well how it's done. That's a very simple way of saying we're going to come up with an idea for how much the company is worth, and you'll buy some percentage of the shares for some dollar amount. But it doesn't have to be done that way. There's things called sweat equity, which is essentially where someone is working a job for the company and maybe they get paid less as a salary than that job otherwise would pay them. And the difference in that amount gets used to kind of buy ownership percentage that they build over time. There's other more creative ways too, but generally speaking, like figuring out if you're going to bring on a business partner, how are they going to contribute and how much are they going to ultimately own of the business? Role definition is also important. A lot of times people think that if you own the company, you also have to work on it, and that's not necessarily the case. Sometimes people contribute finances and basically collect a percentage of the profits at the end of the year, and that's their only role there. Sometimes they are acting as a treasurer or a president. Sometimes they're more of, kind of like I mentioned, a salaried position where if they're working more hands-on. So figuring out exactly what you want everyone's role to be, that's important for building into like a bylaws or a partnership agreement. Equity distribution. So again, this is an area that could lead to dispute. Are you planning to always take profits at the end of every year? Is it going to be more frequent than that because you take profits at the end of every month? Or are you going to be reinvesting the equity or any amount of money that the company earns back into the company? And then, of course, how is that being divided? Is it going to be based purely on shares, which is the most common? If somebody owns 50%, they get 50% of the profit. Or you're going to find out another solution, another arrangement. And this is important to figure out ahead of time again, rather than after the fact, after the company's been operating for a while. Um, Insurance considerations. So there's a lot of different types of business insurance you can get. Some of it's pretty common, like liability insurance or property insurance if you own something. A lot of times I recommend for people to get what's called directors and officers insurance, particularly if you're in a nonprofit or something like that. This protects you from being sued individually just for being on a member of a board or president. And another common one is what's called a buy-sell agreement. So just as an example, if two business partners own a business 50-50, one of those business partners were to unfortunately pass away, um, and the normal procedure, unless you plan for it ahead of time, excuse me, would be that their share of the business gets passed as property as part of their estate plan. So you could have your business partner's 50% passed to their spouse, and now that spouse owns the business and they may not have any idea what to do with it. They may want to get out of it. But unless you have the money to buy them out, that can be complicated also. So what sometimes people will do is essentially have the business take out life insurance policy on both of the business partners. If one of the partners passes away, then their spouse, rather than getting those 50% of the shares, they are paid out from the life insurance proceeds. So now the 100%, the other living business partner gets 100% of the business, but the spouse and the family get paid out for what the business is worth. So again, you have to plan for that ahead of time, but it's a good strategy to kind of make sure that you're not in a tough situation if something like that happens. You can do something similar for disability insurance as well. And with that is exit strategy. So obviously, planning for death is one way, but you can also plan what happens if somebody wants to leave the business. And I'll talk about this in the next section, but in New York, if you don't take the proper steps to plan for exit strategies, you could end up in a situation where you may not even be able to leave the business, even if you want to, without basically getting the court involved, which is going to take time and money. It almost becomes like a divorce. So talk about that in the next section. So partnership disputes. There are a lot of different causes of partnership disputes. First of all, I want to start by saying that most of the time when people have a dispute, they start out as either as friends or sometimes even spouses, and basically go into it thinking, oh, we'll never disagree on anything or we'll be able to work it out. And then something changes and it's been 10 years and they're fighting over finances, about how much to reinvest in the company, about whether to maybe pivot into different areas. Maybe they feel like one of them works significantly longer than the other and isn't getting paid more. Whatever the dispute is, it can kind of, nobody goes into a business arrangement expecting a dispute. So not to say that everybody who goes into business with their friends or spouse is going to end up in a dispute, but it's good to plan for it, just in the same way you might plan with a prenup or something if you're going into a marriage. So one of the most important things, again, this falls into the contracts line, but drafting comprehensive partnership agreements, making sure that as much as you can detail who's getting paid what and when, how much, how can people get out of the business, dispute resolution clauses. So you can even have two partners in the same business go to a mediation or an arbitration to resolve their issues. Just because they're in the same business doesn't mean they can't handle it that way. And another big thing is ensure there's no chance of 50-50 deadlock. So a big thing, especially if you download like a template from the internet, a lot of the times they don't really have a plan for a 50-50 deadlock. If it's 50-50 partners, they basically just say each partner gets to vote. And well, what happens if they completely disagree? So the issue there is that again, under New York law, if you don't have a plan in place, a 50-50 deadlock where no one is willing to resolve it by changing their vote, Sometimes the only option is to dissolve the company altogether, which obviously isn't great. So there's some ways that you can plan for that, whether it has to do with um, putting in, like, you could have a third party who's not necessarily an owner of the company, but maybe they get a tiebreaker vote. You could have a 51-49 split. There's some options you can talk about that are creative, but don't set it up where you have a 50-50 deadlock. That's a recipe for disaster. Um, Dispute resolution, again, like the tie-breaking situation, you could have those options I mentioned for there. Buy-sell agreements. So I mentioned that in the case of somebody who's getting life insurance and who dies, but you can also build in a buy-sell agreement as an exit strategy. And so that kind of works similarly, where you basically have the parties contract ahead of time into if somebody wants to leave the business, how are we going to resolve this? How are we going to determine the value of the business? How is the payment terms going to be met? And this can be helpful because if you have people agree on the procedure while they're getting along, while there isn't a dispute, then that is a lot easier to deal with rather than waiting until after there's a dispute. So planning, again, just more of a proactive approach of trying to find a way to get an exit strategy built into it. And as I mentioned, when things go wrong, owners may not be able to leave the business if you haven't planned for it ahead of time, like LLCs, for example, under New York law. If there's no wording built into the bylaws about how a owner is able to leave, then your option is to dissolve the business or don't leave, or or find a resolution, but the resolution can take time and money and dispute. And a deadlock could need a court ruling. So again, we don't want to end up in a spot where two partners can't agree and they have to go to court. It's much easier to figure out other options. So I see another comment that came in. Says you were giving great advice about being proactive in including clauses in the contract. What about the cost of enforcing the contract through court, arbitration, debt collectors, or other ways? What are the typical costs to enforce contract? So that's a great question. The answer is going to vary wildly on the method that you're using. So I'll briefly talk about, since we have a little bit of time, the difference in ways that that lawyers charge for their fees. One of the ways is called a contingency fee. So if you are a plaintiff, this is oftentimes the most beneficial to you. Basically means you don't pay your lawyer anything unless they recover for you. However, that usually means the lawyer is going to take a good chunk of whatever recovery they can get. 35%, give or take, is usually around what to expect for that. I can say for myself, as a small law firm, I do not take contingency cases, so I don't have great direct experience with that. But a lot of times, high volume plaintiffs attorneys do that type of work. Again, the risk to you is basically nothing. You just would lose out on a good chunk of what you could potentially recover. Another option that lawyers do is called flat fee. That is essentially where they say, I will perform whatever service you want, and I will only charge you $2,000 no matter what happens. I don't know of any lawyers that will do flat fee for any sort of debt collection or litigation, because it's way too complex and it's impossible to predict how many hours are going to need to go into it. So very rare that you would get that there. And the more common way is an hourly rate. So that is just literally the number of hours that the lawyer works is how they bill for. And the reason that's hard to predict is because anytime you add another party on the other side, so now if we're talking about resolving it through court, arbitration, whatever it may be, there's going to be a back and forth. And you never know if the person on the other side is going to be extremely cooperative, and maybe you can resolve something in a day after, one or two conversations, or if they're going to be extremely combative and they drag things out for months or even years in some cases. So that's one of the reasons why being proactive is so important, is because as soon as you get into the reactive stage, the potential timeline and cost is impossible to predict. There are people that, can, in complex litigation, can go on for years and spend hundreds of thousands of dollars. Obviously, you wouldn't rack up those fees if you're chasing a $30,000 balance, but the point is it can be expensive. So I know that's kind of a roundabout answer to the question, but those are the most common. You're either going to find a lawyer who's going to take a percentage of it in a debt collector space. That's almost always what it's going to be. They'll take it on, but they're going to get a percentage. And then you're either going to get the same arrangement for litigation, or you're going to be paying hourly, which can vary differently based on the lawyer you go to. So hope that answers that question. All right, so here's what we covered today. Being proactive can really help resolve a lot of issues with non-paying clients or vendors who don't fulfill their agreements. I really recommend that you plan ahead for growth, whether you're hiring employees or adding business partners. Make sure you figure out what laws apply to you and what agreements you need beforehand. But with any of these situations, if you haven't done the steps beforehand, it's never too late. Always better to get something in place sooner rather than later. And just be aware of options that you have to navigate partnership disputes, and as I mentioned, the potential risks of not having something in place. So that's a handful of the topics. Again, I tried to address the most common questions that I hear clients ask, but there are a number of different ways that business lawyers can help. It depends on what you need, and always a good idea to ask the question sooner rather than later, even if you don't need a lawyer services ahead of time. Kind of knowing that you took those steps can be really helpful, give you peace of mind. So as a thank you to everybody who joined today, I do offer a 30-minute consultation. I'll post a link in the chat, but basically sit down if you have any questions, have a clear action plan to address some of your concerns, identify any challenges that your business may be having, and hopefully leave you feeling that you're prepared to build, grow, and protect your business. My contact information is on the screen there. Again, I'm going to post the link in the chat. So feel free to use that. That again is first come, first serve for over the next week or two. I have some time that's set up specifically to anybody who attended here. But if you can't get on the consultation or you just have questions, again, please feel free to reach out by email or phone, and my number is on there. And is there? But I guess beforehand, is there any other question? I don't think I missed any, but if there's any last minute
You
questions.
haven't missed any so far.
Okay.
If anybody does have a question, we have just a couple minutes left with Alex. So pop that into the Q&A box or the chat right away if you do have a question. Alex, I want to say thank you. This has been an amazing amount of information in 1 hour. I cannot believe how much we have covered in 1 hour. It's fantastic. So let's see, we do have a question about SEAP. And so if you are a part of the SEAP program, I am putting, let's see, making sure I'm typing it correctly. There's an email that you can contact for SEAP verification if you do need that. And so Alex, just to, in your experience,
Mhm.
so what, out of all the things that we went over today, and you have a practice dealing specifically with small business owners, um, what are the things that you do see most commonly out of all of these things that we've covered today?
Sure. I think one of the most common things I see is people who start out by not really getting anything formally documented, whether it's contracts or bylaws or things like that, because a lot of the times you're looking to go, you know your business really well, you know like the types of clients you're reaching out to and finding that business coming in. But things like creating a good set of bylaws or contracts is probably not top of mind, and a lot of people don't really have the capital when they're starting out either. So suddenly a few years go by though, and it really just takes kind of one dispute or one issue that comes up for people to realize the importance of it. So a lot of times people reach out to me, it's because they had that issue with the contracts or with not having contracts or not having corporate documents that they need. And I think the most other common thing is just a lot of times people do feel like, well, what do we do if a client's not paying me? Is it worth the cost of hiring a lawyer to go after that? And obviously that's going to depend from situation to situation and how much is owed. But that's another question I try to answer, from a practical standpoint of I'm not the type of person who wants to get hired just to get hired. If it's going to cost you as much to hire me as it's going to be in potential recovery, then there's no point. It's not a good use of your resources. So that's a conversation I have a lot with people too.
Excellent. Thank you. I appreciate your perspective on that as somebody who is dealing with small business owners and legal matters all the time. Kind of knowing where people run into trouble the very most is helpful. So if you've been in attendance today, make sure that you've got your contracts in place. Alex gave so much great information about that. that's, I think, one of the biggest take homes is get your contracts the way that you need them to be so you can prevent a lot of these problems from ever happening in the first place. So with that, we will wrap up today, Alex. Again, thank you. Thank you to our attendees. And you'll see a survey pop up on your screen as we close the webinar. If you have a few minutes, we'd love to know what you thought about today's webinar and what other topics you would like to see training from the NYSBDC on. All right. Have a great rest of your day, everyone.
Thanks, Jenny. Thanks, everybody.
Bye-bye.